All right, let's dive in. Today, we're unpacking a massive showdown that's putting federal power itself on trial. You've got a presidential order, a governor digging in his heels, and a judge who basically slammed the brakes on the whole thing.
And wow, this quote from Illinois' governor really gets right to the heart of it, doesn't it? This is the core of the legal and constitutional firestorm that kicked off the 2nd National Guard troops set foot in Chicago. It sparked a huge fight over where the president's power ends.
So things really came to a head when Judge April Perry stepped in with an emergency restraining order. She effectively blocked President Trump's plan, bringing the entire operation to a screeching, legally binding halt.
Now, you gotta understand, this wasn't just some vague threat. Troops were already on the ground. And this wasn't a quick in-and-out mission either. We're talking about a planned 60-day deployment to support federal immigration raids and protect federal personnel. 2 full months.
So that brings up the big question, right? How does a state's own National Guard get caught in the middle of a legal firefight between their governor and the president? This really cuts to the core of how our system of government is supposed to work. Who is actually in charge here?
At its heart, what we're looking at is a constitutional tug of war. It's this classic power struggle between the states and the federal government over who gets to control these very unique military forces.
Okay, so here's how it's supposed to work. Normally, day to day, the governor is the commander-in-chief of their state's National Guard. Simple enough. But, and this is a huge but, in certain national emergencies, the president can federalize those troops. That means he takes direct command. And that's exactly what he tried to do here. But he did it against the governor's will.
And that's the absolute key to this whole thing. The order came down without any request from Illinois. The state's elected leaders didn't ask for it, they didn't consent to it. That direct bypass of state authority is exactly what set off the legal alarms and triggered this immediate court challenge.
So with the courts now involved, the president's team pulled out a very old, very powerful, and frankly, very controversial legal tool to justify the action: the Insurrection Act. And just like that, an old law was thrust into a very modern fight.
Yeah, you're seeing that right. 1807. This law has been on the books for over 200 years. It was created for a completely different America, which is why its use today is so heavily debated.
So what exactly is the Insurrection Act? Well, in a nutshell, it gives the president the incredible and extraordinary power to deploy the U.S. military on U.S. soil. The whole legal debate today is whether a law designed to, stop a full-blown rebellion can be used for routine policy enforcement, especially when nobody's claiming there's an actual insurrection happening.
And the president hasn't been shy about his willingness to use it. In this quote, he's on the record saying he'd consider using the act if the courts tried to block his orders. That kind of statement really raises the stakes for everyone involved.
Now, it's really important to see that what's happening in Chicago isn't happening in a vacuum. It's not some isolated incident. It's actually the latest chapter in a much larger national story about testing the limits of federal power.
I mean, we've seen this playbook before, right? The president has threatened or actually deployed federal forces in places like Portland. There's been talk of doing the same thing for Los Angeles. And for New York City, too. And the common thread running through all of these is often a dispute with local leaders over immigration policy. That makes Chicago the latest flashpoint in a long, simmering fight.
And you just can't separate any of this from the political climate it's happening in. The whole conflict is being framed around immigration. The timing, happening in the run-up to the 2026 elections, is hard to ignore. And this kind of assertive rhetoric and action is widely seen as a strategy to fire up the president's political base.
So, where do things go from here? Well, a judge may have hit the pause button, but make no mistake, that's just the opening shot. The real high-stakes legal battle is just getting started, and it's probably going to escalate fast.
The legal path forward is pretty much laid out. Step 1 is an immediate appeal of that emergency order, but most experts think this isn't going to stop there. The betting money is on this thing going all the way to the Supreme Court. And if that happens, the final ruling won't just be about Chicago, it'll set a massive precedent for presidential power for decades.
And if this does end up at the Supreme Court, what then? Well, the outcome is anyone's guess, but you absolutely cannot ignore the court's current makeup. It has a 6-3 conservative majority, and that includes 3 justices who were appointed by President Trump himself.
That's a huge factor that will shape the legal strategy on both sides. When you strip away all the politics and all the noise, this is the one question the courts will have to answer. Can a president take control of a state's National Guard against that state's wishes just to enforce routine federal policy? That is the central issue here.
And that forces all of us to look at a much, much bigger question, one that goes way beyond Chicago. It's a question that could really define the future of American governance. In our modern world, where do we draw the line on presidential power? And maybe more importantly, who gets to draw it?